This is the fourth in a series of short videos that will provide information about the Family Homes on Reserves and Matrimonial Interests or Rights Act, or the Act. We will look at how the Act defines the rights of a surviving spouse or common law partner in the event of the death of their spouse or common law partner, specifically as they apply to the Family Home on Reserve.
The provisional federal rules in the Act apply when the First Nation has not yet enacted its own matrimonial real property laws. Section 14 of the Act provides that a survivor who does not hold an interest or right in or to the family home will have an automatic right to occupy the family home for a minimum of 180 days after the death of their spouse or common law partner, whether or not they are a member or an Indian. The provisional federal rules may be accessed by those who need them. This does not mean that a survivor must access the court system in order to resolve matrimonial real property issues. It may be possible to come to an agreement on division of property or temporary exclusive occupation of the family home. However, as a result of this act, when necessary, a survivor can seek resolution through the court system. The surviving spouse or common law partner also has the right to make an application to the courts under Section 21 to be granted exclusive occupation of the home beyond 180 days, whether or not they are a First Nation member or an Indian. This application can be made even if the family home is band-owned or a rental unit. It could contain conditions such as the requirement to continue to pay rent, to maintain the property in a good state of repair, etc. Though not a full list, some of the factors that the courts must take into consideration are the collective interests of the First Nation members, the best interests of dependent children, the terms of the deceased's will, the length of time the applicant has resided on the reserve, the applicant's financial situation, the applicant's medical condition, the terms of any agreements between the spouses or common law partners, the availability of other suitable accommodations, and the views of any person who received a copy of the application, for example, heirs or beneficiaries. The surviving spouse or common law partner must provide a copy of their application to the Chief and Council. To protect the collective interests of the First Nation, the Chief and Council have the right to address the courts regarding the cultural, social, and legal context that pertains to the application and to present its views about whether or not the order should be made. The court can also make an interim order that would allow the surviving spouse or common law partner to stay in the home after the 180-day period while waiting for the outcome of the application for the exclusive occupation order. The implications of the exclusive occupation order after the death of a spouse or common law partner could impact not only the surviving spouse or common law partner, but also the heirs, beneficiaries, or property owners. First Nations may need to educate all of their members more broadly on this topic. Where a right or interest in or to a family home may still be transferred to an heir or beneficiary, their use and enjoyment of the property could be delayed if an exclusive occupation order were granted by the courts. In addition, a surviving spouse or common law partner is able to make an application to receive half the value of the deceased spouse's or common law partner's interest or right in the family home and of other matrimonial interests or rights. If the court determines that the surviving spouse or common law partner is entitled to an amount in respect of that interest or right, they will not be able to benefit from the deceased's will or from the provisions of the Indian Act in respect of the same interest or right. In other words, the surviving spouse or common law partner will have to choose between receiving an amount under this Act or an amount or right under the will or the Indian Act. Administrators and executors of estates will have access to information regarding the options for survivors that may affect the estate administration.
For further information, please visit our website at COEMRP.ca. This video is for information only and should not be relied upon as legal advice. Individuals should always obtain legal advice from a lawyer familiar with their specific circumstances and the provisions of this Act.